Hey everyone, this is Sunny Justice with It's a Crime and Shame. And this is to do with the defendant's request for discovery pursuant to IC.R.16, okay? And CD had sent these 4 pages. Thank you very much, CD. And on page 2, there was something that he said to look at. So we're going to go over this. Some people, again, like things to be read. Other people don't. So, of course, you can scan through it. But sometimes I just like to break it down and to put it into a visual form and then read it, because a lot of people do like that. So, again, Bryan Kohbergers' preliminary hearing is set for June 26th of 2023. He forgoed the right to a speedy trial and no bond was set. And so I'll just continue. So I'll read this. And again, if you guys could like and share, that would be amazing. If you're not a subscriber, please consider becoming a subscriber. And other than that, let's get into it and we'll start reading the defendant's request for discovery, as we just talked about. And again, especially attention to page 2 as we go over that. Okay, so the prosecuting attorney comes now, Bryan C. Kohberger, by and through their attorney of record and Taylor Public Defender, and pursuant to Rule 16 of the Idaho Rules of Criminal Procedure. The Idaho Rules of Evidence, the 4th, 5th, 6th, 8th, and 14th Amendments to the Constitution of the United States, Articles 1, whatever that word is, 1, 2, 13, and 17 of the Constitution of the State of Idaho, hereby request disclosure of information, evidence, and materials pursuant to ICR 16 and the aforementioned constitutional provisions, including but not limited to the following information and evidence and materials. 1. Statement of defendant. Permit the defendant to inspect and copy and or photograph any relevant written and recorded statements made by the defendant and or copies thereof within the possession, custody, or control of the state, the existence of which is known or available to the prosecuting attorney by exercise due to due diligence, and also the substance of any relevant oral statements made by the defendant, whether before or after the arrest, to a peace officer, prosecuting attorney, or his agent, and the recording testimony of the defendant before a grand jury which relates to the offense charged. 2. This is one here. Statements of co-defendant. Any written or recorded statements by a co-defendant and the substance and any relevant oral statement made by a co-defendant, whether before or after an arrest, in response to interrogation by any person known by the co-defendant to be a peace officer or agent of the prosecuting attorney, or which otherwise relevant to the offense charged. 3. Defendant prior record. A copy of the defendant's prior record, if any, as if then or may become available to the prosecuting attorney. 4. Documents and tangible objects. Permit the defendant to inspect and copy all books, papers, documents, photographs, tangible objects, and copies of portions thereof which are in possession or control of the prosecuting attorney, are which material to the preparation of the defense, or intended for use by the prosecutor or as evidence at trial, or obtained from or belonging to the defendant. And we'll go over right now into what exactly a co-defendant means, because that was very interesting on page 2 about the co-defendant. So here's an explanation of what was on a Google search. A co-defendant is a third party other than the defendant in the case in which another co-defendant is charged and is by nature a witness. To ensure the defendant's right to examine the witness, such co-defendant should be treated as a witness who shall give a sworn testimony and be examined by the defendant and or his attorney before such testimony can be admitted as the basis for determining an offense. You know, remember when Bryan was arrested and it was tweeted by Brian Enton about the fact that he asked if anyone else had been arrested, as if, preluding to the fact that there was somebody else that obviously, he was either trying to play a head game with, or perhaps that potentially it could be true. Was it just Bryan Kohberger in the vehicle, which seems most likely, but who knows? So it was very interesting. Again, thanks CD for pointing that out into. And Adam again has thought it was odd and strange, and obviously it is, and it might mean something, it might mean nothing. Either way, it's still in there, and perhaps if a second person comes to light, who knows? Anyways, continuing on. So 5, reports of examinations and tests permit the defendant to inspect any copy results or reports of physical or mental examinations and of scientific tests or experiments made in connection with the particular case that are in possession of the custody or control of the prosecuting attorney, or the existence of which is known or is available to the prosecuting attorney by the exercise of due diligence. 6, state witnesses. Provide a written list of names, addresses, phone numbers, and or reasonable means of contact for all persons having knowledge of relevant facts who may have been called by the prosecuting attorney as witnesses at trial, together with a NCIC report and a Spillman report of any such persons. A, provide the statements made by the prosecution witnesses or prospective witnesses made to the prosecuting attorneys or their agents, or to any official involved in the investigatory process of the case. This includes statements to the employees of the prosecutor's office, such as witness coordinators, and all members of any law enforcement agency that has had any involvement in the matter. 7, expert witnesses. Provide a written summary or report of any testimony that the state intends to introduce pursuant to Rules 702, 703, or 705 of the Idaho Rules of Evidence at Trial or Hearing. The summary provided must describe the witness's opinions, the facts and data for those opinions, and the witness's qualifications. The underlying facts or data that form the basis of any expert testimony pursuant to Idaho Rules of Evidence 705. Disclosure of expert opinions regarding mental health shall also comply with the requirements of I.C. 18-207. Okay, 10. Search warrants. Provide all documentation in support of any search warrant issued in connection with this case. Applications for search warrants, whether granted or denied. All affidavits, declarations, and materials in support of search warrants. All search warrants and all search warrant returns and inventories. 11. Exculpatory evidence. Provide to the defendant all materials evidence within the scope of the Brady versus Maryland, and then the cases there, then their agencies specifically, and all favorable or exculpatory evidence, information, and documents in possession of the prosecuting attorney's office or other agency or person available to the prosecution through due diligence. Okay, number 12, inducement. Provide to the defendant all documents pertaining to the existence and substance of any payments, promises, and leniency, preferential treatment, and or inducements or threats made to prospective witnesses within the scope of United States versus Giglio, and then Nepal versus Illinois and their progeny. 13, identification, disclosure of whether a defendant or any other person was identified by lineup, show up, photo spread, or similar identification proceeding relating to the offense charged, and production of any pictures utilized or resulting therefrom, the names, addresses, telephone numbers of all identifying witnesses. 14, evidence pursuant to the IRE, pursuant to the ICR requirement of mandatory disclosure, the prosecution must disclose the general evidence of other crimes, wrongs, or acts it intends to introduce at trial as required by the IRE 400B of State versus Grist, 147, Idaho, etc. 15. Electronic surveillance disclosure of the defendant's status as an aggrieved person as defined by the 18 U.S.C. 251011, if applicable, and copies of all records and recordings related to the all electronic surveillance and set forth in the writing and the circumstances thereof. 16. Drug tests. Provide a copy of all documentation generated as a result of performed drug tests by the state's agent for drug identification purposes, including types of testing performed in the case, testing procedures, reagents, and other solvents used in testing, comparative analysis performed, and number of experiments performed in each test. 17. Subpoenas. Provide copies of each and every subpoena issued by the state of any person or entity, regardless of whether served or not, in connection with this case. 18. Certifications. Provide verification of the hire date of all law enforcement officers that may include be called as a witness in this matter, and who were involved in the investigation and or arrest in this case. Provide a copy of the post certification for all law enforcement officers as identified above. Thank you very much for watching this video. Please again like and share or subscribe if you have not. I am Sunny Justice with It's a Criming Shame. My co-host Aspen Connor and myself typically hold lives on Wednesday, Friday, and Sundays, and sometimes we just go YOLO and do them as they come up or involved. Don't forget, tomorrow is for the Delphi murders, which would be Richard Allen, and of course he has his two hearings tomorrow at 10 and 11.